So we'll be just starting in
Sure, no problem. I got it.
starting in 5 minutes.
Okay.
Good morning, sir. Am I audible? Yes, audible.
Okay. Okay, sir. So I'm starting with the introduction. Good morning, dear participants. The Alternative Dispute Resolution Cell of School of Law, Manipal University, Jaipur is delighted to see you all present here for the third day of Bootcamp on ADR Basics. For today's session, we have Mr. Anirudh Guntu. We welcome you, sir. It's an honor to have you with us today. Mr. Guntu is an experienced legal counselor and legal consultant with a demonstrated history of working in commercial arbitrations, mediation, litigation matters, and commercial disputes. He is highly skilled in legal strategy and compliance, business strategy planning, and commercial negotiation. He has participated and advised in numerous mediations, conciliations, and arbitrations through his legal career and has played a key role in helping many startups grow. He is empaneled as a commercial mediator and certified as an international mediation advocate by the Indian Institute of Arbitration and Mediation (IIAM) as Standards and Competencies in Mediation Advocacy UK (SCMA UK). He has also been inducted as a life member of Indian Institute of Arbitration and Mediation. He is also an associate member of the Chartered Institute of Arbitrators UK and is an alumnus of the prestigious program of negotiation by Harvard Law School. Participants, please note that your attendance form will be released in the chat box itself by the end of the session. And sir, will you be willing to take the question in the middle of the session or by the end?
So will we? So I'll start off by talking a little bit about the topics, and also I was told at the that many people are having a lot of questions to do with ADR. So then I'll be taking those towards the end.
Okay.
Anyone
So
has questions also, you can ask me right at the end of the session.
okay, sir. Okay, sir. Thank you. So without further ado, let's start with the commencement of our bootcamp. Over to you, sir.
Sure. All right. So a very good morning to everyone here. I know it's a fact that we all are working on a Saturday, and then the students also must be complaining about it. But for us professionals, this is just like any other ordinary day for most of us. So we'll also try to be making this as interesting as possible. So hopefully you guys won't get bored throughout the session. So I'll be starting off by actually to talk about the damages and the different type of damages. And I want to also bring out the relation that how we can bring it into ADR and how the same can be also brought into those perspectives and how we can mediate also on those matters, mediate, arbitrate, or conciliate, and how negotiations can even happen on some of those matters. So I'll just quickly be sharing my screen with you. Oh, hi, Ayush, I'm disabled from
Yes, yes, sir.
participation.
Sir, one second. I'm making
Yeah,
you the co-host.
sure.
Yes, can you share now?
Just 1 second. I think there's some people also in the waiting room. Yeah.
Yes.
How do we do this? All right. Just give me 1 moment. Okay, I guess I'll just continue. Okay. So yeah, claim and damages. So when we start off by claims, like, so this is going to be pretty basic. So we're going to be talking about most of the basic aspects when it comes to claims and damages. I think it's mostly based on a first year subject. So I'm going to try to keep it as simple as possible. All right. So when we start off by talking about claims and damages, there are various claims and damages that we see. So the first one is liquidated. So there's two types actually: liquidated damages and also unliquidated damages. So liquidated damages are basically the amount of the compensation that the injured person for the injured person, which is already predetermined. It is usually also paid in the cases of where the contracts of both the parties are already known to each other, and before the damage is caused to any of them, the courts only have the option to just enforce these type of damages. So basically, what we have to intake when it comes to liquidated damages is that it goes all the way back to the point where the contract negotiation itself is taking place. So when your contract is being negotiated, you must also try to determine as to what is the exact amount of damages that you will be expected to face, and how you will also be able to recover them. And it is also up to you to even convince your other alternate, the other party as well, as to saying that this is going to be the damages and this is already predetermined. So that's one part. And unliquidated damages are basically the ones it's just the opposite of the liquidated ones, where the amount is undetermined, and that you leave like if, and so the position arises where you need the damages to be taken care of, then you leave it up to the courts to decide about that. And then so if you ask me, like it works in both ways. You either have it as like it could either be in your favor, or it can also go totally against you. It depends on how you plead your case towards the court. So now, and then after that, again, we have this nominal damages, contemptuous damages, compensatory damages, aggravated, and punitive. So nominal and contemptuous are pretty much the same, where there has actually been not much of a damages. Nothing exactly has taken place, and where the person who has faced any damages has been injured in any sort of way. Mostly those people, but then the only difference between those two is that in a contemptuous damages, the person has actually faced some damage, but it's very minor damages, that where the person he actually didn't like, the court actually even takes it that they didn't even suffer one actually, and then it's just a trivial case that they have put down, and it causes them a lot of problems to the courts, and they can actually be even was a fined against even wasting the court also on such type of damages. Now, compensatory damages, this is the point where we have to also note down. When it comes to compensatory damages, these type of damages are just basically there to bring back the individual who has faced the damage back to the same position where he had lost himself. Like for instance, I was like, let's say that I had a factory worth 1 crore, all right, and then through some problem happening there, and then someone misusing or have some damage happening to that factory because of some chemical, let's say some small explosion or something happening because of some problem. So I lose that factory in the process. But then, instead of, so I will be trying to get back to the original position of what I have lost. So I'll just be getting back the exact 1 crore itself. So I won't be asking more than that. So it brings me back to the original position I was in. Now, however, when it comes to aggravated and punitive damages, these are the two damages where the court actually will be giving you a higher amount of money. That depends, obviously, depends on how well your case is also played against them. So aggravated damages, basically, like if the person has faced such things such as like his loss of self-esteem, pain, agony, or he has some lost of specific character, or he has faced some like personal damage where it cannot be compensated by monetary, just it cannot be calculated on a monetary basis. Then the court will obviously will be putting up a higher amount, and then the same amount goes to punitive damages. But then these damages for punitive ones is to also punish that the defendant for even for causing such damages towards the plaintiff's party. So now we move on to damages and penalties, the difference between them. Sorry. Yeah. So as we can see, like basically damages and penalties, these are more on uh, let's say the easier way to determine between these two is by saying the intent. One is based on intent and one is by a tortious act. All right. So then, like when you have, for instance, damages can also, as we have discussed earlier, damages can be predetermined. While, however, penalties are used to punish the individual, which is pretty obvious into this fact. So then, like for instance, like a normal instance that can be taken upon this is that if a person has to pay a specific amount for a contract that's been done. All right, but then if there is an additional amount that also has to be paid along with the amount that is already determined, it could be said that the additional amount is a penalty which could have been done for a breach of the contract on some certain aspect. Like an illustration could be that a certain payment was not made, but then the contract term has it that if a payment is made late, so then he will be incurring 5% as a penalty amount. So then that amount will be added as a penalty amount towards it. So then I'll be moving a little bit more forward right now, and then I'll be also circulating towards the organizing committee the same presentation, and also I'll read up. So then where there is be more details for all these aspects that will be mentioned upon it. Yeah, and also, so also to further go on to the same matter also. So basically, the penalties are also made in order to also to put the fear into the defendant, to the party, to not to make sure that they do not default on it, on the same matters. Right. So now we move on to. Right. So now damages and indemnity. So as we all know that indemnity is basically the part where we try to regain our money for a certain loss or foreseeable mention when we in through contracts. So however, when we are deciding about the penalty clauses and then the damages and the indemnity clauses over here, so we also have to, when while drafting the contracts, we need to see as to what on what basis we are putting down the indemnity part. Now over here, for especially for contract negotiators, should also be taken into fact when it comes to the idea of indemnity, because they have to make sure saying that they have to make sure that they cover all the aspects as to what comes under indemnity. For instance, it could be because of natural disasters, it could be because of bankruptcy, or it can, if it's a supply and demand agreement, then maybe if there's a no procurement or sale of goods, if there's a problem within that, then that's also a problem. And if any one of these parts are missed out, then it become a bullet in a smoking gun for the defending party to use it against the plaintiff party to gain their way. And now, as we have also mentioned earlier and seen it, that damages is basically the predetermined amount. But then when it comes under indemnity, it could be because of various other situations. And also for indemnity, you can also claim indemnity losses based on the action of a third party, which may also not receive result, or which may not necessarily result in the breach of contract, but then it could be done because like maybe that they have you don't have a contract with a third party, but because of an NDA that was signed between you and your party, between you and your other party, that there was a breach of confidentiality between the party 2 and 3 that affected party 1. So when that happens, then you can also claim your damages according to that. Like you can raise the indemnity clause and claim your relief as per those clauses. Right. So now we'll quickly move on to calculating damages. All right. So over here, when we move into calculating the damages, there's some aspects that we have to also take into mind. So whenever there's a tort that has been committed by the defendant, or that there's or the lifespan of the plaintiff is reduced, the amount of damages which will always be awarded to him is calculated without taking into the consideration of the individual social status. So the damages that we are talking about at these aspects is that it is given to make sure that person will live that he will be provided for the loss that he has suffered, and also for a happy life. Now, however, when this for a happy life, meaning that the life that he is already having, like he'll be able to live that like he will be able to live that in a proper comfortable manner. So how but then, like, if that person thinks that if like I in the future I would have become some millionaire, billionaire, and all sorts of stuff, then that's not going to be taken into consideration by the court. That the person, that what life he is presenting at the moment, that should be taken into consideration. And to talk about this, there's two theories over here: the interest theory and the multiplier theory. Basically, in these two theories, the first theory, these two theories have been determined by the court. The first theory, if you ask me, it's more like it's basically a deposit, like an interest deposit, where a lump sum amount is just is deposited, and where the interest upon that amount is used, it will be given as a compensation to the party, for an n number of years, for the like and to like if so it's like kind of like a monthly, it's, if you ask me, it's like more like an FD that's been given by the court in these type of matters. So the multiplier theory, as you can see, so the best illustration I can give for the multiplier theory in this aspect is, for instance, we say that the person, by working in a certain factory or in a manufacturing plant, he suffered some sort of an illness from from some safety guidelines and all that have been misguided, which have not been looked properly into, that have been neglected by the owner of the company. So then with these type of guidelines, so then this determines the fact that, like, for instance, in the future, where the person is going to be having a degrading disease, like for instance, like let's say he's gotten cancer, which will slowly be acting upon his lifespan and will be reducing it. So then this type of multiplier theories are used in order to compensate him for these number of years, like it will be multiplied into the number of years, like which will be determined by the court, saying that, for instance, let's say that he has about 10 years as a life expectancy, even more. So then the amount will be multiplied into that 10, and it will be calculated amongst the same for the pain and suffering that person suffers. So now one question might be coming up to everyone is that, like, will the idea of inflation be taken into regard when it comes to when determining damages? So yes, it does take into determination. The courts do take that. In these two cases, it was mentioned that because of the raising rates, expenses, and everything that's there, it's not fair for the plaintiff to be only given this amount, but only not to be able to live the proper life when there's a continuous raise in these prices. So the court has decided in these cases that this will be the situation. Now, so then later on, there's some more formulas as to where and how these aspects and all are given, and how it there be calculated by the Supreme Court. Right. So that brings the end to that presentation. However, just give me 1 minute.
So are you done with your presentation?
I'm almost done. Just give me one moment. I'm just trying to get this back.
All right.
Uh, can you? I'm just going to exit once and I'm going to come back. All right. Oh, wait. I think I just found the file. All right. Yeah. So I'm back right now. Yeah. So now comes to the part where I really wanted to talk about. So it is that it's about proving these damages. So now, as many of you professionals and litigants also must be knowing in this meeting today, how do we prove these damages? So what we'll be needing to prove these damages is that obviously you will need to have copies of your communications. You need to have the pictures of your documentations, and also any evidence that you find that will be viable for this. For instance, let's say that you're having a health aspect that it has been done, like you have suffered, like for instance, like we can see in the case where Johnson's, there was a suffering on that aspect where they said that their baby powder was causing cancer in babies, and even other people or even their products was doing the same. So what you need to do is that you need to have these health reports, documentations, or even if you lost in goods and if you lost some goods as to your purchase, so your proof of payments, and how those goods have also suffered, like how you have loss of those goods have made you suffer, and all those. And even if it's a service-based ones, how the denial or the irresponsible act of those service providers, how did that make you suffer in your services or in your daily routines and your daily life, or as we are all working from home. A perfect example could be that where if you're proper without proper internet connectivity, as to how that made you had created a lot of problems, and how that might have costed you a lot of loss to your businesses. So now when you are proving these damages, now this is where main part where ADR came in. Like all these aspects that I was talking to you up till now, all right, this comes when you are pleading in front of the court. But now when you are here proving your damages, or when you're even in your contract negotiations, this is where your true skills actually come out. Okay, I am so sorry. I think my power is fluctuating a little bit over here. Sorry, I just lost my flow of thought for 1 second. Yeah. So this is where it comes out, because based on your evidence and your negotiation procedure lays the foundation stone of your future, if in case that you have any um, problems that arise. Like for instance, when you're in a contract negotiation and your price is already determined, but is that the price you actually wanted? Was that the amount that you wanted to have in your damages? What if you suffer tomorrow and a higher amount in your damages that this price is not sufficient about? So that these aspects have to have to be taken into display. And now when you're gathering your evidence, what type of evidence have I gathered? How can I use this against him or her? How can I claim that my right based on this evidence that I have gotten? Do I have enough to sit at the bargaining table to determine my position? All these aspects have to come in. Basically, idea of ADR and negotiation is that you need to think that we have to take into aspects of the long term approach as to what happened, what is going to happen, and how do I safeguard my position, and in case this has happened, now how do I counter it? How, if this situation comes up, how do I counter this? So these are some of the aspects that are coming up. Now, the main point also where we also see that where disputes also come out is by, frankly, if you ask me, is by because of basic human psychology. It could happen because of clash of egos, misunderstandings, miscommunications, and basically just because of normal behavior when it comes to at least commercial matters. And these aspects are easily can actually be taken care of through processes such like conciliation and mediation. But then to those to come out, we have to also try to determine as to what person's psychology, like try to break the person down, try to see where he happened, if this is the problem that he has suffered, or where you might have made a mistake. And also when you are at the table, to put aside all your differences and to just speak it out together. Because if today you can reconcile, because tomorrow today's reconciliation can also maybe lead to better business perspectives and longer business relations in the future as well. So yes, if anyone has any doubts or anything, I will definitely love to speak about those. Anya?
Yes, sir. There's a question. What if there's some document which goes into the wrong way for your client, like it shows in the negative way, and the other counsel asks for it? So, what would be the right thing to do?
So the right thing to do will actually you should be giving him that document, all right? But then also make you have your you already make a defense statement also prepared already, knowing that this is going to go the other way. Because if you're, as I said earlier, like you know already that this is going to be going in the future. Like you have to play the long game strategy. So meaning that you already know all your weaknesses in your own argument. You know that this document might not work for me. So then the best idea will always be honest, put the document through, but then also be ready for a counter as to why, as to against that document.
All right, sir. Another question is, when are the arbitral awards binding for the parties, and does the parties have the right to go to the court after that?
Yes, parties do have the right to court against that, but then, however, nowadays they have. So I think in the latest amendment that has come out, that you need to also prove as to being into these parties awards. Like you, for instance, you have to find out like if there was an issue where um, like if there was anything any manipulation that was happening with the arbitrators, like if there was anything that's against you, or if the arbitration award that he have passed is not up to your satisfaction, then you have to be brought towards the court, and also at the same time the arbitrator will also be called towards the court at those times.
Right, sir. So we have a question from one of the participants.
Answer that question as well. Yeah.
Hi, good morning. Um, you have demonstrated, highlighted two type of, damages. One is penalties and liquidated damages. I just want to know the difference between these two. You have already demonstrated that. If you could give me give us the circumstances where the liquidated damages are more appropriate and where the penalties are more appropriate. If you give some kind of circumstances, it may be useful to understand.
Okay, so you're basically asking where liquidated damages versus penalties, right?
Yeah, right.
Okay. So, for instance, let's say, like, so penalties, let's start off with the penalty part. For instance, I'm a service provider, and then I'm a service provider, and I have to provide, like, and then you ask me for a certain services, or there's a certain services that are to be rendered. So when the services are being rendered and all that, you sometimes you expect payments also to be done on times, or even when it comes to even proper goods, when goods is supposed to be given to you, or when you're also the one supplying goods. So then penalties is basically given to, I can say the penalties can be the best reason, if you ask me, is when there's been a delay on payment. Because if that payment does not reach you on time, right? So then that could cause you a lot of problems. But then at the same time, it might not cause you more damages where you will be totally incapacitated, but you want to put the fear into the another person, saying that like you will be penalized about 5% on the total amount. That 5% of the total amount will be added on if I don't pay the amount. So just to put the fear into them, that we put the penalties. Now, however, for liquidated damages, now let's say the fact that these goods have been provided to me. Now I buy raw material from one person, I make a good, and I sell it to another person. All right. So now this raw material that comes up to me is of a is of an inferior quality, which obviously destroys my product, which decreases the quality of my product, and I'm sending it to another person. So, but then, however, now that person will sue me, saying that you are giving me an inferior quality of a product. But then you already have a predetermined contract that says that if such damages come up, where an inferior quality, etc., is also given, that you will be compensated so and so amount. For even this could be also used for the legal procedures and problems that he'll be also brought up in the future. So for such situations that we can say liquidated damages for that. I hope this was okay.
Thank you. Thank you so much.
So there's a question in the chat. Could you please explain the statement indemnity claim may be brought before the breach of contract?
But
Indemnity claim may be brought before breach of contract.
yeah. So basically, what happens? So what is a breach of contract? A breach of contract is when the terms of the contract are already broken, right? But then indemnity is basically like a damage that has been given for the thing. For instance, like a payment that has to be made, all right, but the payment was not done. That is called a breach of contract, or a supply has not been given. These are the basic terms of contract. Now, indemnity can be also done for natural disasters. Let's say that he is put it in a go down. We have an onions. The guys makes is an onion seller. So then that because of a lot of rains that have happened, he's lost his crop, right? So then what the problem? So then the calculation of the amount of crop that's been lost due to rains will be the indemnified amount.
Okay, I hope that answers the question for Yukta. Another question is, can deflation will be considered while calculating damages?
You mean inflation, right?
That's what the participation asked. I guess it's inclination.
Inflation. So then, yes, inflation will also be considered while calculating damages. That is actually a very deep aspect that you need to keep in consideration when you're talking, when you're at the negotiation table, especially talking about that. And also one aspect I might also think and say that when you're talking, when you're at a private company, and you're talking about damages and etc. damages, or even in your mediation, you're talking and you're breaking a deal. So when the income that you're going to be getting, you have to also decide to see if this will be, if this is amount is pre-tax or post-tax, and try to take it into the certain tax laws that you might be coming forward into determining these amounts, and how you'll also be calculating it yourselves.
All right, sir. The participant asked deflation. So is that wrong?
I'm not exactly sure about that, so that's why I spoke about inflation.
All right. So a lot of participants had a question about what do you do in during law school and after law school to get into ADR? What's the pathway of this career prospect?
So I would like to say that when you are the pathway towards this current prospect is, first of all, you need to. This is not like this is a certain field where you need to develop your skills more. You have to know how to talk to a person. Like you'll be yelled at, shouted at, and all sorts of stuff. But you have to learn how to control your emotion. Emotional intelligence is what we may basically need when you get into ADR. But then, for instance, like if you're looking more into advocating yourself and to advocating cases, then arbitration is the perfect position to be in. But then when you are also looking into conciliating, and also when you're into mediation, then you have to start looking into how to start reading about human psychology, start reading as to how to approach a person in a neutral manner, look into your own body sense, look into people's emotions, how to work on the emotions, and also try to understand their problems. Now, how do you also get into it is that you have to start. You can take up some training courses at various institutions from all around. There's many institutions all around world, just like in the Indian Institute of Arbitration Mediation (IAM), where they have a certified mediation processes and all. That's however, if you're going for an institutional mediations. So that's what these are one as few aspects in doing, and I also suggest that if you are very keen on getting into ADR as a purpose of practice, then start trying to work with a lot of law firms, individuals who already work into this aspect as well, and also keep reading about it and try to bring it up. And also now online also there's a lot of new platforms that are coming out, like for instance Sama, Cord, and there's a new ones also that are coming up every single day. Try to work as a case manager, try to get in and work as a case manager and an administrative person in those type of forums, so you'll start understanding and also gain an early practical knowledge also on the aspects of ADR.
So there's a question on the chat.
Precisely explain the difference between conciliation and arbitration. Right. So in conciliation and arbitration, it works like so in arbitration, it's basically like out of like you have an whole act and all that. That's the other aspect of it. So the arbitrator will be the one who determines the um, judgment, and he will be giving the award for that purposely thing for the, I'm so sorry, for the dispute at hand. In conciliation, however, you give the parties a chance to negotiate also amongst themselves. They try to reach an ideal situation where both of them come to a mutual and neutral understanding, saying that okay, this works. All right, and that same decision is also binding. That same decision will also be passed by the conciliator, which is also binding. But in arbitration, the difference is that the arbitrator is the one that makes the decision for the parties.
Okay, I hope that answers the question. So this is my personal question. I was told that for the career pathway, one should first start with the first, you know, find a particular domain in which you are interested in for the arbitration. For example, petroleum and gas problems and different industrial problems. So first we have to master one domain and then we can come into arbitration. Is that so?
No, that's actually not the aspect. That's if you are already working, like for instance, let's say I'm a civil engineer. All right. I'm good in, like, I've been working as civil engineer. I know all the aspects about it. So after some 16, 17 years, I'll become an expert into that field. So if you are already working in a domain and then you'll be brought in as an arbitrator only for a specific field, that's if you are a professional in a certain domain. Okay. So then if you want to, but then as a lawyer and you want to become an arbitrator, I say that do not stick to a particular domain. You branch yourselves out, work in all these certain different aspects, and then that will help you into determining a lot more cases. Now, the particular one that you have mentioned was only for the cases where you are brought in as an expert arbitrator or expert subject matter arbitrator in some certain amount of cases. So for instance, even however, also lawyers, also like if you, they have a dispute in like, let's say like, as you said, like the petroleum business. So we also, they will reach this institutional arbitrators and try to see that if they can find somebody who has a particular skill set when it comes to petroleum disputes. Like if they have been in the field for a long time, because they feel that those people, like the people who are experienced in those fields, will be able to determine their case in a proper manner.
All right, so we have a question. Just a second.
Yes, good afternoon, sir.
Good afternoon.
Yeah. Sir, other than in India, the other countries where they treat marriages as contracts.
Mm-hmm.
Excuse me, am I audible, sir?
Yes, you are. Please go ahead.
Has been treated as, hello?
Yes, yes, please go ahead.
Hello?
Hello.
Yes, sir. So what happens in the other countries other than India where the marriage has been treated as contracts? Are they sent to arbitration or mediation or conciliation? Because in India, we send the couples to the mediation and conciliation. What happens in the other countries?
So in other countries, they do go for mediation as well, because when it becomes a contract, or when it becomes if it becomes on the basis of a contract, then they try to at least try to see the divorce settlement as to how the negotiation process will take place. This is the splitting of assets and all that. That's however, all this takes place if there's not a prenup that's in place already. If there's a prenup already in place, then it's just going to be enforced by the court. In India, however, so
So
in India,
prenup in the sense something like an arbitration clause?
no, so a prenup, so then in a prenup, it basically gives them as to the rights and duties of like the rights of the parties and the circumstances under which they'll be even getting the assets in the first place. So if there, so then there might be a dispute settlement clause in it where if there's a so and so, like if they don't determine like on what basis the assets are being given out, then they might be sent to a mediation first as to then the parties will try to talk amongst themselves and try to come to a mutually agreed a mutually negotiated prenup agreement as to like how the assets and all are supposed to be taken care of. And then if that does not work out, then again then there can be an attitude also that will be called in.
Okay. Okay. Thank you, sir. So, and one other question. Can I go ahead?
Please go ahead.
Yeah. In a previous session on day 2, we had the other speaker saying that we can get ourselves enrolled in institutions for free of cost as being a student and get our membership acquainted.
Okay.
So is it possible? And when I checked it out, there were so many institutions, but none of them were offering like free memberships. So is there any institutions that you are aware of or anything, sir?
Okay, so I don't, so then the institutions I'm aware of, so they have like the free memberships and all that, those are based mostly on, they have just certain periods of times when those take place for the free membership part. But if you're a student, I think the Chartered Institute of Arbitrators, you can try with them. They have a, because as much as I remember, they do have a student
Okay.
discount. They
Okay.
do have a
Okay.
student
Okay.
discount.
Thank you, sir. Thank you. Thank you so much.
All right. So if there's no question, then we'll be moving forward with the competition tips that you'll be giving for the negotiation that happens in the law schools.
Yeah, okay.
Hello.
Yes.
Yes, Ankita.
Yes, am I audible?
Yes, you're audible. Please go ahead.
Hi, very good afternoon, sir. I wanted to ask you about in the other session, the speaker told us about you can also join as an arbitral secretary or a tribunal secretary, administrative secretary. You can start your career like that. So I want to know how I can apply. Like, should I have to approach to the arbitrators and mediators that are still practicing in India, and I have to approach them, or like what's the procedure for to apply as an administrative secretary or a tribunal assistant?
So one part you can do is that, so there's two ways in how you can start trying to get this particular knowledge. So some forums and all that, they have case managers where you can apply with them and then they will help you. So then you will also be working along with the conciliators on the case per case basis and helping them in determining those cases, which is there for this ODR platforms. So you can try to apply with them and try to work as a case manager for all those. And also for yourself, for administrative secretary, yeah, I think you need to see if there's any arbitrators, or if you know any arbitrators, try to approach them and try to just email them with a proper SOP and try to talk to them saying that if you have any positions, if I can come for, if I can work for it. However, if also these positions are also given to you for free, and if you have the, if you want to, if you're very keen, and then they tell you they cannot pay you at the moment, do try to get all the experience that you can, and also try to also get the certification, like try to go through many other dispute resolution trainings also online, so that will also look good for your CV and your application as well.
Thank you so much. That answers my question. I have one more question, if you can allow me to ask.
No problem.
Yeah, so I was looking for the arbitration courses offered by CIARB, or like say SIC, the Singapore Institute of Arbitration Center. Yeah, so they offer the courses they are like 1 or 2 days of courses, and even in IIAM, it's like hardly it's like a week of courses. So is this enough really, a week of training to be arbitrator?
Yeah, see, these courses will only bring you the initial certification that you need. Okay. After that, everything you do is on your own skill development. You have to push yourself into it. That's the thing when it comes to ADR. Like you won't be finding like month-long courses and all sorts of stuff. But then at the same time, you need to push yourself. You have to study about it. You need to start building that into a practice. If you're a advocate, if you're an advocate at the court, try to build your practice into all these type of things. Push your clients into saying, let's go for mediation, let's go for arbitration. Bring it up as an extra resolution for them. As I said before, this is a skill development based on your own perseverance. Other than that, then that's it. Because when it comes to institutes will only give you the basic tools. It's after that, it's based on how you use those tools to sculpt your own future.
All
That's how.
right, thank you so much, sir. So it's all based on your skills and how you can, harness it.
Exactly.
Thank you so much, sir, for this knowledge. Thank you so much.
So
Yes.
there is another question by one of the participants.
Yeah, by Geetanjali, right?
No, sir, Bhagesh.
Yes, as well as Gitanjali, but let's first do Bhagesh then first.
Yes.
Okay, can you please tell me Bhavish's question? Hello,
Uh,
Bhagesh.
for some reason, yeah, go ahead.
Uh, good, a- yeah, good
Yes.
afternoon, sir.
Good afternoon.
Yeah, sir. Previously, you were telling about the how to calculate damages. So,
Mm-hmm.
sir, for example, sir, my friend met with an accident,
Okay.
and when he go to hospital, and doctor suggest, the doctor has also done the various surgeries and postmortem report, and that's IPR CR report. And sir, that examined liquidated damages have been examined, and the court also, and the insurance company, and the third party who has done the default has also abandoned compensation, but there are such damages which are not imagined by an report. So sir, my friend will we can we claim compensation for unliquidated damages or not, because they are not imagined.
Okay, so basically for this situation, I'll have to actually go through the whole details of the case to exactly give you a determined option regarding it. But then what I can say in this current situation is that um, it depends on how the court actually has the court given the damages, like have they determined the damages that has been given?
Yes sir. Yes.
Okay, so the court has already given the damages. So are
Yes
you
sir.
happy with the damages, or are you saying that you are unhappy with the amount that has been given?
Sir, I'm unhappy with the amount because my liquidated damages have been calculated, but my unliquidated damages have been not calculated because unliquidated damages are not recognized in the IPR CR report, in postmortem report.
Okay, so your friend has basically passed away. Is
Yeah.
that correct?
Yes. Yes.
Okay. So what I will say is that the family for these type of cases that they take as to how much that child, like the future of that child. All right. And if that child was a single earner, sole earner for that family, for the future of that family, like let's say that the child was the only child in that household, and as the parents old, that they were dependent on that child. All right. For the future of like for them to being supported by that child. So then it depends on also about how much, what degree he was holding, and also what he could have been owning potentially in the future. All right. So then that's one part that where you can talk to the court and say that this would have been the amount. This would have been the amount that this child would have provided to this family to support his parents for then and the ailing parents who were not able to work. So that's one aspect to look at it. Second aspect will be saying that if you try to put up another case against the person, then you try to talk with your lawyer and ask the other party to come up with you, and maybe you guys can come up to another understanding or work out for an out of court settlement. But that's to do with your But for that, we'll need to look into the merits of your case and also any other further aspects as well.
Okay, thank you so much, sir. Thank you so much.
Yeah, any more questions?
Yes, so there is another question by Gitanjali.
Okay.
Sir,
Yes,
the
sir.
Chartered Institute of Arbitrators for a student membership, they ask for a recommendation letter or upon the experience in ADR. So how can we get there? Is it the same was as being an administrative secretary?
Yeah, so when you, for instance, like exactly, like it's the same like as being verified an administrative secretary, you can ask the person who you're working with to give you a good recommendation letter. That's about it. Just put it towards that, or when you work with any other ODR platform as well. Over there, you can also ask them, like, as if I can get a experience letter saying that I worked on so and so cases and all that. So those should be able to help you for this.
So there is another question by one of the participants. I'm unmuting.
Good afternoon, sir. Am I audible?
It's a little bit low, but yeah.
I had a question about LLM in this field, ADR. So I was
Okay.
going through the LLM in international arbitration, especially from the University of Singapore. I was thinking of expanding my career into this field. What do you think I should be doing right now in terms of my experiences? And is that course worth it? And what will be the future prospects of that course if I go with it?
So I think the future in ADR, when it comes to especially arbitration, that it is excellent. Like this
Okay.
is the like this is exactly where that the country is moving towards, and also recently even the CGI, Mr. CGI, he has also given he's been given a lot of support towards dispute resolution and working studying dispute resolution in a country like Singapore, where they're one of the front leaders of they're one of the pioneers and even the leaders when it comes to dispute resolution. I think it will be a perfect idea for you to go ahead with it.
Okay. Okay. Thank you so much, sir.
Yes, sir. So can we go ahead with the negotiation tips?
Sure, definitely.
Yes, sir.
All right. So yeah, so for negotiation tips, basically what I've seen, so I've judged a lot of competitions. I've seen exactly what goes on over there, what goes on in these competitions. So one part I would like to say in the negotiation competitions is that try to come up with good deals. Like when I mean like good deals, like out of box deals, like come up with different terms in this and structure those deals in a proper way as to what will be proper for your company, like what will be good. For instance, from many mistakes that I've seen that what a lot of participants do is that they're like, just give me this much amount, and then they just start talking the merits of what they're asking for those cases. But then if you're just asking for that, that does not work in a negotiation. Instead, ask it like this. For instance, let's say that I'm starting a startup of my own. All right. Now I'm talking with my investor saying that I need 5 crores to come up with my investment. I need a 5 crore investment into my startup, right? But then, however, the investment, he will not give you just 5 crores. Like he'll be calculating, like you're talking to him, you're telling him about your passion, but he won't. But then he also needs to feel as to why do you why need to just give him blank 5 crores right there. So instead, structure that deal in a proper way. Put it like a different holdbacks. For instance, like a holdback is when a certain aspect of the deal happens that that the amount will be released at that certain point. For instance, let's say that the proof of concept, once you like you will as the proof of concept is submitted, that you'll be releasing maybe 50 lakhs for that. Then 50 lakhs will be released after that. Then after that, let's say that for office furniture, office space, and etc. For that, we'll be needing another 1C. 1 crore for that. So aspects like this need to be structured properly when a negotiation competition. And also when you're in a negotiation competition, you have to be, especially what I just said, be good in these aspects. Now, for instance, let's say that you're the goods holder in this prospect. You are not going to, that you have all the cards in your hands, and the other person is the one that, but then you want to give, you want the other person's business as well. So for this parts, you have to also try, you have to give some and take some as well. So for instance, that you will have to be the one, like he'll say that I need this money for this thing, that thing, this thing, that thing, and all that. But then you come up as to the conditions. You build up this thing saying that this is how I'm going to give you the money. This is how it's going to work. Or this is the timelines I expect you to work at, right? So this is just for some parts in that. So when it comes to, for now, when it comes to even I think there was a question that was raised on client counseling also, right, Anya? Hello.
Sir, actually, she's having some network issues.
Yes, yes, I'm here. I'm so
So
sorry.
like, I think there's a question that was also raised for the client counseling, right? I think I received.
Yes, client counseling as well as the arbitration mood. This was a, I wanted to know the difference as well.
Okay, so arbitration moods, I'll just tell you one thing. Say arbitration moods, just make sure your pleadings and all are done properly. Like it's basically like it's kind of like a moot court, but at the same time over here you're dealing with an arbitrator. So just make sure your laws are done, your pleadings are done properly, and that you're well versed with the certain how the cases are going to be taken care of. Now, when it comes to, however, when it comes to client counseling ones, this is also one more aspect. I've seen a lot of students like they go inside, like over here, you have to act like a proper business like a business salesperson at times. This is one aspect I feel that law schools do not teach us. So when you walk inside, when you're going for client counseling, start off by talking to the person, like make them comfortable, make them feel like opening up towards you to explain the full merits of your case. And also over here, you have to also be good as to what exactly you're suggesting to your partner, to your client as well. Make sure that you're up to date with all the latest legal mechanisms, know what's going to work, the jurisdiction of the cases, and all of those as well. For instance, like that, let's say that it's an IP case that's going on. Like how I'm saying, like when you try to talk to your client and to being nice with them, for instance, like first, like smile at them a little bit. All right, smile at them when if the person's like an artist or like a musician, just tell them like things like I would love to see your work sometime, or I love to come to your exhibit, I would love to hear your music whenever you can, when you're able to share it. So these aspects do actually make the person open up more towards you. So as they open up, they start even giving you more and more information, which might even prove crucial to it. And now, what I think law students and many advocates and even law practitioners should also do also from now onwards is when as they're even counseling their clients, is that bring out the ideas of ADR into it. Tell them, saying that, ma'am or sir, we can bring this into mediation. If in case mediation fails in this aspect, then we'll take it to the court or we'll go into arbitration from that point. And also when it comes even towards this whole thing, like one main aspect I really tell everyone to do is that make sure your contracts has this type of flexibilities in it.
Right, sir. Thank you so much for the tips. So, if there's no other question, then I'll be moving forward with the vote of thanks. Yes. So, first of all, thank you so much, sir, for giving out such your valuable time for us all to be here and giving such a real life webinar, which is not at all common, right? In these times. So, thank you for that, and thank you all the participants to join us for being here today. And I would like everyone to open up their cameras for a group photograph, please.
Also, I'll be emailing you the materials I've made, so it can be just distributed as well. So it's
Definitely, sir. We'll be mailing all the participants any materials which you'll be giving us. Yes, thank you so much, everyone, for joining. Thank you, sir.
thank you everyone.
See you.